I'm Advocate Pradeep Shukla, practicing at Bombay since 49 years. While preparing my other cases, I come across the matter connected to the Arbitration Act. Now, under the Arbitration Act, the court has a power to change the arbitration, but there is a word called obligates. Now, in one of the case, what had happened was that the High Court misinterpreted the word obligates and pending the proceedings, ordered to change the arbitrator. Now, this was something unique decision anyway, but that's a High Court judgment, so the matter went into Supreme Court also. In the Supreme Court, the argument was similar arguments that court has exercised the power under the Arbitration Act and therefore it should not be disturbed. And the High Court order of changing the arbitrator should be maintained. Now, for changing the arbitrator, there can be so many other reasons. We are not going deep into the facts of that matter. But the Supreme Court has interpreted the word obligates. Now, what the Supreme Court has considered that this is a very serious decision of the Supreme Court which will be helpful to so many advocates and litigants, that of course there is a power. The court said that under the Act there is a power, but that power cannot be misused in all the cases like this. There are different special facts, situations to be considered by the court, which will enable the High Court to pass an order of change of arbitrator. It's not general act applicable to everybody, and whenever the party wants can approach the High Court to change the arbitrator. The Supreme Court has specifically given guidance in that judgment that only on those circumstances where it is proved that it is compulsorily in the interest of justice that arbitrator should be changed. Otherwise, just because there is a provision in the Act, it is cannot be applied generally to each and every matter, and on application of the party, the High Court changed the order to change the arbitrator. Now, this is really very important judgment, and definitely it's not a general public litigation, but then there are so many corporate clients which so many advocates must be dealing with. I also deal with such matters, so that in those cases this judgment will be really helpful. I'll just give the citation of that judgment. It's a party's name is Viva Highways Limited versus MP Road Development Corporation. The case is of 2026, Supreme Court cases 195, which is decided recently on 6 February 2026. So, any big companies, corporate clients who are dealing with such matters where the arbitration proceedings are going on should take care of this judgment and can utilize this judgment also. Thank you.